My paper speaks perhaps more to the issue of transparency than due process as such. Since I began working at the ICTR, since 2005, I repeatedly told potential defense witnesses that if they agreed to testify for the defense, and they harbored fears about testifying for the defense, that if they testified under a witness protection order, that only those who absolutely needed to know that they were testifying would know. So when I made these representations, I believed they were true, and I believed that the witnesses were relying on these representations. In 2009, on the 9th of March, I discovered, and I think the public discovered, that I had been lying to the witnesses, unbeknownst to me. The reason being that the ICTR had a registry practice in place, a policy, whereby it transmitted the identifying information of all witnesses who were resident in Rwanda, who were under protective court orders, to the Rwandan Prosecutor General, who then transmitted the information to the Ministry of Justice, who then transmitted the information to the Department of Immigration. To dispel one possible preconceived notion, I'm not sure if any of you have considered this, but there have been both Hutu and Tutsi Rwandan survivors who have testified for the defense. So it's not exclusively one side for the other, or the other that has testified exclusively for one party or the other. The reported reprisals that I'll be mentioning today are exclusively related to ICTR defense witnesses. And the reason for this is that I have no information on reprisals against prosecution witnesses. And I would welcome any information from Prosecutor Jallo or anyone working in the prosecutor's office who has additional information to inform my reflections on this issue. The typical protective measures when someone is afraid to testify generally include a series of 10 or so clauses, provisions. And the two main ones are that the other party that is not calling the witness is prohibited from contacting the protected witness unless authorization of that witness is obtained for contact and the lawyer representing that party is present during the contact. And the second important clause in witness protection measures or court orders is that the names, addresses, whereabouts, and other information that might identify or assist in identifying the witnesses and their families, this is called the identifying information, shall be sealed by the registry and shall not be included in public or non-confidential records. WVSS is the ICTR section that is responsible for implementing court-ordered witness protection measures. The reported cases of interference, I will begin with a brief background and then specific examples. The background to the fears of defense witnesses is essentially Rwanda's socio-political climate and the oppressive regime that is in place. These have a chilling effect on the ability and willingness of witnesses to testify for the defense. They fear that they will, or that their family members will suffer reprisals. Allison who was a key prosecution expert witness and is often referred to as the mother of the ICTR, testified, I think it was in the Renzaho case, that she had testified for the defense at one of the Gachacha cases. And she herself was threatened, if not disagreeably warned, for testifying in that case. The judicial system in Rwanda has also been used to stymie political opposition. We have the case of Victoire Ingabire, which has been followed closely by Amnesty International and other human rights organizations. There are genocide ideology laws. There are tools that are used within that society that effectively dissuade people from voluntarily, I guess, or freely coming forward with their testimonies. There's often a failure to respect defense rights in Rwanda. In 2010, Laurent Nkunda was placed under house arrest, not allowed to have contact with his lawyer, not allowed to have any trial, he was not informed of any charges against him, and he's still in that situation today. Agathe, the Minister of Justice, was not tried until 10 years after she was incarcerated in Rwanda, and only had her trial after the first group or series of transfer cases was being heard. The hearing in the first case with defense lawyer Johnny Moikuza. In that case, the question was put to the Prosecutor General of Rwanda what was going to happen with Agathe, and that's when he indicated that the trial would begin soon. It did shortly thereafter. She was convicted. She has since appealed, but there has still been no appeal hearing for her case, according to Lawyers Without Borders in Belgium. So this is the general backdrop to the fears, I guess, that are often expressed by defense witnesses. Now, the specific cases, I'll begin with a Human Rights Watch observation that is documented in the ICTR record. And that is that a number of cases where defense witnesses were detained or charged with perjury, or they were charged with perjury as a result of testimony given in Gacaca cases, that would be in Rwanda. But there are also ICTR defense witnesses who were arrested after they returned to Rwanda, were detained and possibly later subjected to harsher prison conditions if they were imprisoned, and other cases where individuals decided to flee the country or had disappeared after they had testified. Specific cases that I can give you today are the Kamuhanda case, Mugiraneza, Renzahu, and Gatete. Kamuhanda is a case where two prosecution witnesses, after they had testified for the prosecution, contacted the defense investigator who resided in Rwanda to recant. They went back to Arusha, recanted before the appeals chamber. After they had returned following the recantation, the Rwandan authorities prosecuted both those witnesses alongside the ICTR defense investigator Leonidas Nshigoza. And as I mentioned yesterday, if you were here during one of the presentations, there was no immediate response by the ICTR to Mr. Nshigoza's incarceration. Yet the story is somewhat complex. If you have questions later, I can get into details later. But suffice it to say that you had Rwanda prosecute two ICTR witnesses who recanted their testimonies. In Mugiraneza, there was a defense motion to hold certain, if I'm not mistaken, they were prosecution witnesses who were allegedly intimidating and harassing defense witnesses. The trial chamber ordered the registry to file submissions, investigate and file submissions, and the court record is actually silent on any such submissions, so they might have been filed confidentially. But what we do know is that there were no contempt proceedings that were issued in relation to that case. The only contempt case at the ICTR was the Nshigoza contempt case, or the only trial. The other contempt case would be a guilty plea by witness GAA, also related to that same case. Renzaho perhaps provides one of the most graphic examples of reprisals against witnesses. There were two key witnesses Actually, I'm just going to summarize because I only have 5 minutes left. There were two witnesses who were killed prior to their testimonies. I would just refer you to page 13 of my paper. And notably, there was a trial judgment issued in that case when, although an investigation had been ordered and required, no proper investigation report was ever submitted to the trial chamber. Renzaho was convicted despite the absence of an investigation report on the intimidation of most of his witnesses, if not at least a dozen, I think. The appeals chamber, in reviewing the trial chamber decision, noted that there was an error committed by the trial chamber for having rendered a judgment in the absence of an investigation report, but itself rendered a judgment on appeal, again, without an investigation report. The amicus curiae, who had been asked to provide the report, essentially provided a report that was that had gross deficiencies, as noted by the ICTR registry, but then later died after it was requested by the appeals chamber that he provide a follow-up report. I'm going to very briefly mention in the Gatete case, there were 3 witnesses who died after they testified. These were reported to the ICTR registry. There was correspondence between defense counsel and the registry, which seems to indicate that the registry did not take or consider certain warnings related to 2 of those witnesses seriously. And then 2 out of the 3 witnesses died after the warnings had been communicated to the ICTR. I'm not suggesting for a moment that the ICTR is in any way responsible for any of the reprisals that have been suffered by the witnesses. I'm just trying to underscore the importance and the reasons for the fears that are harbored by defense witnesses. The ICTR disclosure policy, as I mentioned at the outset of my presentation, came about when, in the Inshigoza case, I was on mission in Rwanda. I found out that 2 of my defense witnesses had been contacted by the Prosecutor General's office. I was quite surprised because I assumed, as I indicated earlier, that all the information concerning my witnesses was confidential and under seal. The registry was ordered to, I filed a motion for a stay of proceedings. The registry was ordered to investigate over the weekend and report back the following Monday on whether the allegations were true. And the representative from WVSS confirmed in open session the following. And I'll read, it might take 1 or 2 minutes, but I think it's important for the record. With regard to the procedure that has been used regarding the movement of witnesses, either those who are free in Rwanda or those who are already in custody, Your Honor, we cannot issue travel documents without notifying the country of residence, notifying them of their identity. So you cannot issue this travel document using a pseudonym. And so the country's authorities have to be aware of the identity of the issuance of travel documents. The procedure in Rwanda, and which has been simplified through an agreement between the tribunal and the Rwandan authorities, consists in officially notifying the prosecutor's office in Kigali regarding the movement of all witnesses from Kigali, whether they are in detention or not. So an official letter is sent to them via the registrar of the tribunal, including all the details, witness particulars of the witnesses. It is the prosecutor's office in Kigali which cross-checks the availability of these witnesses and to see if they are ready to come to testify or not. Once this phase has been passed, then the document is forwarded to the Minister of Justice, which then does what it has to do with the file. And then when the Minister of Justice approves it, then the file is forwarded to the Department of Immigration for the issuance of travel documents. And I will just say that in the Inshigoza case, one of the witnesses who is listed in that letter had a valid passport and did not require a travel document. The defense in the Inshigoza case was ordered to proceed with the case, notwithstanding the pending motion for a stay of proceedings. And after the case was over, in May, the trial chamber rendered its decision on the motion for a stay of proceedings. Not surprisingly, the chamber denied the motion for a stay, as it found that the defense was able to call its witnesses and therefore failed to demonstrate how the contact between the Rwandan prosecutor's office and the witnesses had adversely impacted the accused person's right to a fair trial. And I will conclude in the next 30 seconds or so, if I may. In this decision, even though the motion was denied, it's very important to note that the Chamber ordered the WVSS to conduct a review of the internal procedures in relation to facilitating the attendance of witnesses before the tribunal, and the review should address the question of the type of protected information which needs to be disclosed to facilitate the witness's attendance, and to whom. So this speaks to the transparency issue. In conclusion, I will just say that the frequency and nature of recorded threats and reprisals against defense witnesses is sufficiently troublesome to render the concern over whether the ICTR proceedings were conducted with sufficient due regard as required by Article 19 of the statute. And the concern is a valid one. The Bagasora and Rutaganda protection measures from 1997 and 1998, which precede this policy that I just mentioned today, actually included a clause ordering the registrar rather, not to reveal the names and identities of defense witnesses, either to the prosecutor or to any government or the media or the public without the express consent of the defense. Now, perhaps if such a clause had been included in the court orders since 2001, we might not have had the situation where the registry provided all of this confidential information to the Rwandan Prosecutor General. But I'll leave it at that and for everyone's own reflection on the issue.